Good afternoon. My name is Tamara Lawson. I'm the Dean of the College of Law at St. Thomas University in Miami, and I'm pleased to be on such a distinguished panel discussing such an important topic as it relates to police-involved violence, police brutality generally. I've been asked to start the panel. We have so many other esteemed lawyers that are going to be joining us, but to start the discussion, and we do intend for this to be a discussion, so please put your questions in the Q&A chat room box for us to address. The discussion about, or starting the conversation with the history as it relates to police violence. And when I was asked to talk about the history of police violence, I first thought, wow, how far back do we want to go in this conversation? And I first thought of lynching and the work of Ida B. Wells. And that is in the backdrop when we think about police violence. But also in the backdrop are slave patrols, which is part of the history of how organized policing began in the United States. And so there was a unique focus on Black individuals as the slave patrols were formed and exercised their roles enforcing slave codes. And then we historically have the progression into Jim Crow laws, which criminalized intentionally minor behavior. And I will talk about that in a moment and how that mirrors some of the cases that we see even today, the minor criminality that initiates the police encounter and ultimately activates police aggression towards the death of a suspect, even in a very minor situation. Historically, I think it's super important for us to note the monumental brief that was filed at the United Nations at its meeting in Paris in 1951, entitled "We Charge Genocide." And this really motivates the title of one of our panelists, Benjamin Crump, his book, which is entitled "The Legalized Genocide of Black People." But in that famous brief, "We Charge Genocide," it was articulated that police brutality was a major issue in America, directed at African Americans specifically. So we're looking at a system that has been happening for a while. Excessive policing has been happening for a while. Sometimes it's called in the literature and in the documentaries proactive policing, broken window syndrome, additional focus being placed in certain neighborhoods and on certain individuals. Traffic stops in particular, I think, have been a sore spot, really, as these encounters are minor but become deadly. Dateline did a documentary on this exact phenomenon in 2004. You may be familiar with it, entitled "A Pattern of Suspicion." And it was triggered by the killing of Timothy Thomas in Cincinnati. There were riots in Cincinnati because at that time they had killed 18 Black men in a row in the same exact number of months. And this was becoming, much of a different type of pandemic, a different type of epidemic. And their national survey indicated that Black men and boys were more likely to be stopped for non-moving traffic violations, 3 to 5 times more likely to be stopped for these non-moving violations across the country. So it was a way to highlight a type of racial profiling. And remember, non-moving violations are not those that you see prior to the stop. So it was calling into question the proper probable cause or reasonable suspicion in the first place for these encounters to take place. So these minor infractions harken back to Jim Crow, I would suggest, where it was legalized to have minor infractions, disorderly conduct and other things. So when we look at some of our modern cases that have become deadly, let's just quickly sketch, how did the police first learn about these individuals? Jaywalking, Michael Brown. A taillight, Walter Scott. Selling a loose cigarette, Eric Garner. Passing a $20 bill, George Floyd. Walking home, Trayvon Martin, jogging, Ahmaud Arbery, sleeping in her bed, Breonna Taylor. So these cases, I think, strike at the chord of why the history is relevant, that minor incidents become major and deadly. And then we've seen protests of various types as it circles around these issues of excessive force, the take a knee movement, right? And I suggest to you, is the take a knee protest a protest against prosecutors for failing to, pursue these cases? Or is it maybe also a protest against jurors for failing to acknowledge with their vote the criminality or accountability necessary for police officers? Going down that same list, and this is by no means an exhaustive list, it's just demonstrative for our discussion. The grand jury issued a no bill in the Eric Garner case, in the Michael Brown case, in the Tamir Rice case, and a hung jury in the Walter Scott case. So the community outrage was somewhat missing, and that is what distinguishes a criminal violation from a civil wrong. The community condemnation has to acknowledge accountability for criminal convictions. Now, the problem we see in these cases also is there is some acknowledgement of wrongdoing, but it's not so much at the criminal side. We've seen a lot of civil settlement and civil remedy attached to these cases. I call it a shadow system of justice. We see $12 million settled in the Breonna Taylor case, $27 million in the George Floyd case, $1.5 in the Michael Brown case, $5.9 in the Eric Garner case, $6.5 in the Walter Scott case, $6 million in the Tamir Rice case. And is this justice? Is this justice when these same incidents are not yielding any kind of criminal conviction? Now, we do see potentially a tipping point, a turning point in the George Floyd case and the recent conviction of Derek Chauvin for that killing, for that alleged and now adjudicated murder. Is that going to change how jurors look at these types of cases? Specifically, is that going to change jurors' appetite and reception and deliberation as it relates to police-involved violence, police-initiated violence, as I like to identify it, distinct from police-involved violence, police-initiated violence. Now, I just want to briefly touch on a couple areas of reform that are primed in the news and on our list of to-do: qualified immunity and also self-defense laws. These two areas of jurisprudence impact greatly how these cases will be determined. Qualified immunity is still at issue and still pending reform at the federal level and at the state level, and accounts for many cases not being in favor of plaintiffs. And it creates a huge hurdle from the plaintiff side because there's interlocutory appeal and immediate appeal by the defense in these cases. Self-defense laws are the other area which we have seen more movement and improvement recently, where in California and in Washington, D.C., legislatures have approved heightened laws for police officers. What do I mean by that? That police officers must use de-escalation techniques in these cases prior to being eligible to have self-defense opportunities. I see one of our panelists, our distinguished panelists, is joining, so I'm going to yield the floor, but I just wanted to add that the ABA is very active in this area, not just in this important section, but also there is an ABA consortium on police practices, and so we will be continuing to engage on these issues and welcome all of your participation. And I yield the floor to my esteemed colleagues.
Thank you so much, Tamara. That was a wonderful presentation, and it definitely set the stage for us to begin to have that deeper conversation around the increased scrutiny that needs to be given to the overreach and the concerns that we have as it relates to criminal justice reform and the current status of the criminal justice system. At this time, we want to welcome our esteemed colleague, Attorney Ben Crump, former president of the National Bar Association, and obviously one of the foremost civil rights attorneys of our time. And we look forward to him being able to put in context how the history that Dean Lawson provided us with, how that history moves into current day it matters that are affecting the constitutional and civil rights of our underserved, marginalized communities broadly, and the Black community specifically, but how as attorneys we can begin to address those issues and move criminal justice reform forward. And so Attorney Crump, President Crump, we welcome you and thank you so much for your participation today.
Thank you so much, Ms. Swan. To all of you, I pray you can hear me and that you can see me. I acknowledge my NBA immediate past president, C.K. Hoffler. I thank Dean Tamara Lawson, one of the foremost thought leaders as it relates to social justice in America today. And I thank you all at the American Bar Association for having this important conversation, this conversation that many believe took on new life after George Floyd video was released, and it showed this Black man being not offered any consideration, no professionalism, no humanity. And it was this moment that has been presented to America for us to take a proper temperature of where we're at in America in social justice. How far have we come and how far do we yet have to go? And so I'll just start there. Ms. Swan, I think that we've made significant progress when you think about the Black Lives Matter movement in America. It's hard to believe that Trayvon Martin, 17 years old, was walking home, profile pursued, and shot in the heart by the neighborhood watch volunteer almost 10 years ago. 2022, February would be the 10-year anniversary. And I think back to that, President Hoffler, and I think about before Trayvon, how insignificant the criminal justice system and the legal system valued Black life. They would kill us, and Black people, brown people, minorities would get no measure of justice, not in the civil court and certainly not in the criminal court. There would be nobody held accountable for the murder of unarmed Black people who were killed unjustifiably, unnecessarily, and unconstitutionally. But we have made significant progress since then. And it's always a journey to justice, in my belief. You take a step forward, and then there are going to be times you take a step backward. But we must always be focused on justice and moving forward on that pursuit of justice, no matter how elusive it may be because of the intellectual justification of discrimination. What do I mean? Well, I'm here in Memphis, Tennessee today, where we're arguing for the video to be released. His family and our legal team just saw Alvin Motley murdered by a Kroger grocery store security guard for playing loud music. The judge is trying to decide whether the probative value outweighs the prejudicial value. And so the issue is, they say, well, if we release the video, we don't know if we can get a impartial jury seated. And I continue to make the arguments, Dean Lawson, that I have never seen in my life, not once in my professional career, where a Black person has been accused of committing a heinous crime like murder, and the courts or anybody say, well, we're not going to release the video of the Black man committing this crime because we don't know if he'll be able to get a fair trial. But yet, when the roles are reversed, seems like that's the narrative, CK, in every situation, whether it's George Floyd, whether it's Alton Sterling, whether it's Botham Jean. We say, well, we don't know if the white person who killed this Black person in the most unbelievable manner would be able to get a fair trial. Well, I would accept that more if you didn't release videos of Black people accused of crimes every day of the week. But yet, when it's a white person who commits a crime like shooting Alvin Motley while he's smoking a cigarette and holding a beer can, and it's over loud music, you say, well, we don't know if we can release this video because it will inflame the community and we can't have a impartial jury seated. We have a long way to go when we think about what's happening in Memphis today. And so I ask that you all join me in the demand for transparency for Alvin Motley. But that takes me back to the grand jury is going to get this case. And we're going to know if we got a grand jury like that in Ferguson and Kentucky, where they get to put their hand on the scales of justice to make sure that there's no due process afforded to these Black families, or we will get a grand jury proceeding like with Keith Ellison in Minneapolis, or Juliet Holmes, the prosecutor in Georgia with the Ahmaud Arbery case. Yeah, I remember the young man who was lynched for jogging while Black, not in 1940, not in 1950, but last year. And so we still know, even though we've made progress, we have to be ever vigilant. We have to keep writing law review articles. We have to keep writing ABA journal articles about the deadly disparities that exist between marginalized people of color in America and our white brothers and sisters. We have to continue to challenge at every step of the way the implicit bias, not just from the individuals, but from the system itself. We have to continue to monitor the data and question, why do we have an overrepresentation of Black and brown people in the prison industrial complex? Why do we have an overrepresentation of Black men on death row? Why do we have an overrepresentation of Black people as stand your ground victims? We have to take on these, what I call important issues, these important questions. Dean Lawson, some people tend to say they're uncomfortable questions or uncomfortable conversations. I never say that. I always say these are important conversations because nobody wants to do anything uncomfortable, but we all want to do something important. And so I'm thankful that the ABA is having this important conversation to talk about how we make sure that we can have a better America, a more just America, one where Breonna Taylor gets to sleep in peace at night and not have the police bust open her front door at 1 o'clock in the morning and mutilate her with bullets while she's practically naked in the sanctity of her own home, and how we should have been able to foresee that something like this was going to happen to a person like Breonna when we looked at the disproportionality of them executing no-knock warrants 70% of the time in a state like Kentucky on African Americans when Black people only make up 12% of the population. And we have a right to believe that we can have a more just America, a better America where George Floyd gets to take a breath without a police keeping his knee on his neck for 9 minutes and 29 seconds, and how foreseeable it was that in Minnesota, almost 90% of the chokeholds that were executed by police were on men of color. It was foreseeable that you were going to have a tragedy like George Floyd. And then, absolutely, we can have a more just America, a better America, where Ahmaud Arbery can run free and not be lynched for jogging while Black, where Byron Williams in Las Vegas, Nevada won't be killed for riding a bicycle while Black, while Botham Jones in Dallas, Texas won't be killed in his own apartment for eating ice cream while Black, while Pamela Turner won't be killed on video, this Black woman on her back who is yelling, "I'm pregnant," won't be killed for having a mental health crisis while Black. And while our system will finally start to acknowledge the Declaration of Independence in a real and profound way, I say in closing with these two things, the Declaration of Independence that says we hold these truths to be self-evident, that all men are created equally, that they're endowed by their Creator with certain inalienable rights, that amongst them are life and liberty and the pursuit of happiness. Well, America, that means Black people too. And even though we have made progress, we have so much further to go because we have to get the George Floyd Justice and Policing Act passed, because we have to take advantage of this moment. If we don't take advantage of this moment, I don't know when we will get another moment like this. As Professor Lawson knows, it has been 57 years since we've had meaningful, substantive police reform in America. Lyndon Baines Johnson was president, and when he put forth the Great Society legislation was the last time we had substantive police reform in America. And so now here we are in 2021 with an opportunity to finally, and think about in those 57 years, how many Black and brown people have been killed unjustly. That's why we have to pass the George Floyd Justice and Policing Act. And finally, the George Floyd question. The George Floyd question is this, and this is what we have to use as a barometer. When Black people see the video, they say, "Oh my God, That could be me. That could be my father. That could be my husband. That could be my brother. That could be my son. That could be my nephew. That could be my cousin. They know without a shadow of a doubt, it could be any of us. But when my white brothers and sisters see the George Floyd video, they say, oh my God, I can't believe somebody would do that to another human being. I can't believe somebody could be so barbaric, so cruel, so evil. But never, ever do they say, I could see the police doing that to me. And until every American says, whether black, white, brown, or red, when they look at that George Floyd video, I can never see the police doing that to me, then we have more work to do in America. And so I thank you all for allowing me to talk to you in the back of Mount Olive Church in Memphis, Tennessee, as we yet again find ourselves fighting for Black Lives Matter. Thank you.
Thank you, Attorney Crump. Thank you so much for that insight and for those comments. We had said that we were going to have questions toward the end, and I'm not quite certain of how long we are going to have your attention. So I'm going to pose this question to you. I think that you have answered it in responding with the passing of the George Floyd Policing Act that we really do need to focus on. But we have a question from the attendees, and it is, how do we get swifter justice in use of force cases? And we know the federal act, the George Floyd Act, will be federal legislation, but how do we begin to have swifter action around use of force cases at the state and local level, moving individuals in the system forward quicker, and especially police officers needing to be held accountable more rapidly for their actions?
Well, a lot of it is, Ms. Swan, the George Floyd Justice and Policing Act, because as the laws are codified right now, think about what we're dealing with today. And even though he's not a police, they're treating this white security guard with the same cloak of immunity as a police officer. The fact, you always hear about these videos, whether it's Ronald Green in Louisiana, coming out 2 or 3 years later, because they're trying to sweep it under the rug. And the only way we can get to swifter justice is to have transparency, transparency, transparency. We have to have these videos released. It's just asinine. Taxpayers pay all this money for body cam video so we can see what happens, so it could be transparent. And what's the first thing that happens when the police shoot or brutalize a person, especially a person of color? They say, oh, we can't release the video, because that's part of the intellectual justification of discrimination. And when the roles are reversed, they always release videos of people of color accused of committing heinous crimes. We can't have two justice systems in America, one for Black America and another for white America. We have to have equal justice for every citizen in the United States of America. And that's how we will get swifter justice, when we start applying the same rules for everybody. Because they have a gun and a badge, that cannot make them above the law.
Thank you, Attorney Crump. And I hope you can stay with us even longer. We look forward to having you with us for as long as you can possibly be here. And we're going to move on to Brittany. Brittany Reed is an assistant district attorney in Baton Rouge. Assistant public defender in East Baton Rouge. And she's with the Office of the Public Defender. And we are looking forward to her comments as we start to talk about how different individuals in the system impact the overall system. And so, Brittany, thank you so much. We appreciate you being here and look forward to your comments.
Thank you, Ms. Swan. I'm pretty honored to be on this webinar. As Ms. Swan said, my name is Brittany Reed. I work for the East Baton Rouge Parish Office of the Public Defender. namely in the juvenile division. So I only handle juvenile cases. That means anyone 18 and under for all kinds of crimes ranging from first-degree murder to simple damage to property. So I am in my first year as an attorney, but I have quickly come to grasp the reality and the needs that surround the juvenile justice system. And specifically, when Mr. Crump asked why are we seeing mass incarceration of Black people? Why are we seeing, everything going on as far as it relates to people of color? And I want to go back to the fundamental purpose of the justice system, and that was rehabilitation. The purpose of the first juvenile court that was ever enacted was because the public had an interest in rehabilitating youth, not locking them up, throwing away the key, but rehabilitating them. However, decades of delinquency prevention policies focused on control and enforcement rather than positive youth outcomes have resulted in legally sanctioned mass incarceration of youth of color. All too often, juvenile courts become the default response when other systems fail to provide developmentally appropriate support for these youth. This saddles youth with juvenile records, places them within the court system, and potentially puts them on a pathway to the adult criminal system. We know that adult misconduct or adolescent misconduct that is developmentally normative is unequally prosecuted among poor youth and youth of color. In fact, Black youth are nearly 5 times more likely to be confined than white youth. Latino and American Indian and Alaskan youth are 2 to 3 times more likely to be confined. Though the total number of cases, of juvenile cases specifically, has decreased since the mid-1990s, the inclination to criminalize childhood still continues, and the racial and economic disparities remain the exact same. Since we now have an overwhelming amount of research, it shows that detention, even minimal, even the shortest amount of stay. So detention, that's jail for kids. Even the slightest stay in detention affects young people because it exacerbates their symptoms of stress, trauma, anxiety, and mental illness. Detention has been linked to recidivism rather than an increase in public safety. An ideal juvenile justice system would work to minimize the use of juvenile detention and minimize that time that a youth spends in detention. Children who are treated fairly in the legal system, they're more likely to trust their attorneys. They're more likely to trust court personnel, actively engage in that court process, and find value and legitimacy in the court process and their case outcomes. Research also demonstrates that this perception, which is known as procedural justice, is a significant precursor to positive behavior over time. And so while we're talking about this sort of death of the idea of rehabilitation, on the other hand, as far as the juvenile justice system is concerned, we're starting to see a shift. In recent years, there's been sort of a rebirth of this idea of rehabilitation. We're just getting back to what the juvenile justice system was initially designed to do. So many organizations have formed in order to begin to aid and advocate for the rights of children. There are tons of national, state, local level organizations just dedicated to children's rights, advocating for youth, whether that be youth who are committed of crimes or youth who have been abused in different ways, youth who need help with schooling, things like that. And juvenile defense attorneys are now incorporating modern science into our criminal law practice. evidencing the neurological and physical differences between children and adults. Even courts, they're beginning to recognize and discuss how childhood trauma can impair normal adolescent development. At that same token, prosecutors' offices have begun implementing programs to divert children to resources and services rather than taking them, taking it the court route and having them endure that process. I know here specifically at the East Baton Rouge Juvenile Court, our judges, they're trained in traumatic brain injury and how different trauma in your life can affect youth behavior, development, and things like that, so that they, when a child comes before them in court, they have a holistic and clear idea of, okay, does this child need services or does this child need to be locked up? But this is only the beginning. We need to invest more in indigent juvenile defense. Why? I will give you 3 big reasons. The first reason is that effective juvenile defenders save money by keeping youth in the community. The second reason, effective juvenile defense systems increase public safety. Who doesn't want that? The third, effective juvenile defense systems lead to the success of children. This is pretty circular. The more we help the youth and keep the youth out of the system, the more likely they will be productive adults in society. If anyone has any questions, feel free to email me or type it in the chat. Thank you.
Brittany, thank you so much. I think it is so important that we don't attempt to continue to have conversations about criminal justice reform and how we can move an agenda forward without actually focusing on juvenile justice and how having those who are engaged in the system at an early stage, having some intervention at that time. And I speak to that from quite my own experience as starting my career as a parole and probation officer in juvenile services before moving into intensive adult probation. And I know that that work is critical to reforming a criminal justice system. And with that in mind, we are going to move on. And again, please put any questions that you have in the Q&A. We will be answering them as quickly as we can. Meanwhile, we are going to move on to Ariana Guzman Garcia. She is with the U.S. Probation Office for the District of Puerto Rico, and she's a probation officer there. And this information coming from Ariana is really going to speak to our overall federal system as it relates to parole and probation. She too focuses on juvenile parole and probation, but at the same time, we're trying to talk about how the federal services are going to work within the overall system in terms of reform. So Ariana, please begin.
Good afternoon, everybody, and thank you so much for the opportunity to be part of this panel. My name is Ariana Guzman, like it was already presented. I'm an attorney also, but for the past 7 years, I've been a probation officer. And I wanted to give you an overview of the system of how it is working towards reentry and rehabilitation and everything related to criminal justice reform. I wanted to share a presentation, so if you give me one moment here. Okay. Let me put in the slideshow. Okay. So like I said, I'm going to be providing you with a glimpse into the multiple hats of the U.S. probation officer. The main objectives is to provide the overview, but also to describe each and every U.S. probation officer's role within the system. I also want to illustrate the initiatives that we're doing and how there's been a shift in terms of how are we conducting the supervision of federal inmates and the practices that were being implemented since the beginning of the bail procedure. So I think we've already discussed this a little bit, but what is criminal justice reform? We already talked about policing, police accountability. We talk about reforming prosecution practices. We talk about everything related to due process and equal protection of the law. There are other aspects. This is a very complex issue that also include elimination of mandatory minimum sentences, for example, in terms of the federal system, among other issues, including the reduction of mass incarceration. So with that in mind, the U.S. Probation Office, people think that we only supervise inmates when they come out of prison, but we have a very complex role within the system. We not only provide or have to balance the protection of the community, but we also provide services to those persons. And it is important that Brittany Reed mentioned rehabilitation, because that is one of the main focus of our job as a U.S. probation officer. Also, we have to help the federal courts to ensure the fair administration of justice. And how do we do that? We do that through the investigations of the personal characteristics of each client or defendant that we serve, in order to recommend conditions of release that will effectively address the risk factors of recidivism and will in a way also promote their successful reentry into the community. As part of our mission, we also have to investigate, right, the offense conduct. We have to get into that, and we have to investigate also the statutes. So there's a balancing act that we have to do between punishment, deterrence, and providing the services as to rehabilitation. I wanted to give you this is like an overview of who we are. We have a division, the Postconfession Supervision, which of course will be in charge of supervising those federal prisoners that are being released into the community. The pretrials investigation, they have a complex job because they have to look at the least restrictive recommendation as to either detention or release, right? During this particular stage, what we're looking for is to ensure not only the protection of the community, but basically that person is gonna attend the hearings. So least restrictive measures. As part also of the complexity of our system, we have the post-conviction pre-sentence. Basically our job, and that's the unit I primarily work in, we have to address not only the offense conduct, but we also have to look into those 3553 factors, which are the personal characteristics of that person, in order to recommend a sentence to the judge that will not only enable or balance out that punishment matter, but also the rehabilitation of that person. So as we continue throughout the whole system, like we see there, we feed each other. Each division feeds each other. And we're also serving, as part of members of the judiciary, we're also serving the judges. We have to establish positive relationships with the government, the defense attorneys. We're all part of the system, and we serve mainly the court. And that is something that I wanted to share with you. The U.S. Probation Office has a long history. Basically, the most important piece of legislation that we have to look at is the Sentencing Reforming Act, in terms of sentencing specifically, that it was created in 1986. And what it looked for, it was to create the U.S. Sentencing Commission, but guidelines that will impact or reduce the disparity in terms of the imposition of sentences between judges and between districts. Now, what is also important about the Sentencing Reform Act is that it changes the perspective of how we were to perform sentencing. And as part of that, pre-sentence investigations reports took on a whole other meaning. Now, it is important that everything within the federal criminal justice system, we always say before and after Booker. Why? Because this specific case basically make my guidelines advisory. And that gave the judges not specific, but a little bit more of leeway in terms of how they were going to sentence, because they can now take into consideration those 3553 factors, which are the specific personal characteristics and background of that defendant. So in order to avoid sentencing disparities, it also provided that flexibility sufficient to recommend a different sentence based on those factors and taking into consideration other elements of the offense. So reforming the system from within. Within the pre-sentence, like I said, we have to balance those two aspects, the nature of the offense and the personal characteristics of that defendant. And with that, there has been a shift in looking into alternative sentencing remedies that, if not limited by statute, may even include probation. Within the system, we have to make thorough investigations. And why is that relevant? Those reports are not only used by the judge in order to determine the final sentence, but they also impact the supervision division and how they're going to make their risk assessments. So from within, we have to take all of that information to also recommend the conditions of release that will enable that rehabilitation process and protection of the community at the same time. During the last 10 years, and I think we've all known about this, but there have been very important shifts and changes with the First Step Act. Also the First Sentencing Act, which impacts drug reductions in terms of crack cocaine, reductions of statutory safety valve provisions. The First Step Act was also, it's very important in a sense that it encourages BOP program reform. So even though we are moving towards the right direction, we still have a long way to go. But there's this acts, and I would also like to include the amendment, the 1782 amendment, which also reduced the drug quantities, have been effective in demonstrating one thing: more incarceration does not mean less, that there's gonna be more incarceration, basically does not impact the recidivism rate. So what we're actually establishing with the 1782 amendments, the expansion of the compassionate release, is that justification that we use as to more imprisonment time is not enough, because statistics have shown and demonstrated that it does not impact recidivism rates. So what are we doing? Now we're going to move into the supervision area, okay? And as the federal government has shifted from that law enforcement focused vision, it has moved towards the last 10 years or more into evidence-based practices, which is the conscientious use of that data to effectively implement and provide services that not only, again, security, safety of the community, but also the rehabilitation. So where we're developing our strategies are based on the RNA model, which is based risk of recidivism. Who are we going to address with more services? Higher risk offenders of recidivism. What are we going to address? What are those criminogenic dynamic risk factors? Example, cognitions, peers. What are we going to address specifically as to that defendant in order to achieve a successful rehabilitation and supervision? And responsivity, how are we going to do it? What programming are we going to use to address those specific factors? We're using different intervention strategies like STAR, which is one-on-one interventions with the defendant, in which we use a cognitive model, we use effective use of disapproval. We use different ways of talking to a defendant that not only sees him as a mere number, but we're seeing him as a person. So we're intervening with the way he thinks, and in a way impacting the way he behaves. How are we doing this? Also through reentry, the second chance, employment, different initiatives that impact job readiness, housing, education, and of course, treatment. We have to take into consideration that a lot of our populations need treatment with respect to mental health, drug treatment, amongst other. So we're using this different evidence-based practices based on the R&R model in order to ensure a successful supervision. So I just wanted to give you like a glimpse of the cases closed. As you can see, basically it's almost like a 30% of those closed with revocation. So it means that in a way we have to move beyond, again, that vision of revoking just for revoking. We're moving beyond that by programming, by providing services that will allow federal inmates, in this case, achieve a successful supervised release term without any revocation. Now, we are using this table. What it illustrates pretty much, we use a tool that is called the PICRA 2.0, which is a risk assessment tool that not only takes into consideration dynamic risk factors, but also static factors, which, for example, include criminal record. And what is proven, and this is what we call the evidence base, is that the higher the risk level, the higher the percentage of revocation. So evidence reveals to us that for those persons that are in that high intensity risk of recidivism, we have to focus our attention, our programming on them. Because if we do that with those that are low and moderate, we will be setting them for failure. And statistics have shown that. So reforming from the supervision standpoints, we have to start in the arrest. The relationships that we develop with a person who has been left released on bail, we can start there. Of course, we're going to have least restrictive interventions, but we can help them with employment. We can help them with vocational studies. If we start that process of reentry since then, in the end, there will be more successful, and that is what we're looking out for in the federal system. Now, the last thing that I wanted to bring is the impacts of the Second Chance Act. This is a very important statute because it provides funding for programming at the state, local, and tribal level, and also at a federal level. The law enforcement funds allow us to address, based on that risk of recidivism, different programming that would address those specific drivers and risk factors. And the important thing of this programming is to be creative. Districts are being creative in how they implement the Second Chance Act, because they're essential in addressing those cognitions, employment, treatment, necessities of our clientele. And that is why using what we have right now, it's essential not only for purposes of achieving that effective supervision, but also expanding the objective of this, in this case, the Second Chance Act, and the objective of what the probation officer wants, which is to protect the community. But we can do that. How do we do it? By programming, by providing those services and trying to impede in a way that that person returns back to the criminal justice system. So these numbers basically represent the clients that have been impacted at a national level. They may seem like very little. We have to take into consideration how funding has to be administered. But what the Second Chance Act invites the U.S. probation officers across the board, right, is to be creative, okay? To be creative with this funding, because we have alternatives and we can do it addressing different programming areas, including mentorship, specific vocational training. We also have, with this funding, we can address certain barriers, for example, transportation issues that we may have, educational issues that might impede that specific person to understand the process of supervision and successfully go through the process. So the many hats of probation, I hope I've brought you or provided you with a glimpse of the many hats. We're basically, our many hats are pretty much determined by our charter of excellence. And I just wanted to give you that glimpse of what we do and how our impact not only starts at the supervision level, but also at the beginning, since that day that person is arrested. If you have any questions, I hope that I provided you with that glimpse. If you have any questions, put them in the chat. I'll be willing to share anything else. And thank you.
Ariana, thank you so much. That was quite an informative presentation. I have to say that it reminded me of so much that I have probably overlooked and forgotten over the years that I was involved. And it's welcome to have so much information brought to you in such a concise way. So I really appreciate your presentation and thank you so much. We are now going to turn to the esteemed C.K. Hoffler, who is the immediate past president of the National Bar Association, and all opening up all information and in full disclosure. I love the NBA. I am the vice chair of the NBA's Civil Rights Law section, and as well as being a member of the Women's Law Division. And it is an incredible organization. And CK's leadership over this past year has really been phenomenal and has set the NBA on the right course. And so I am so happy and proud that she has agreed to be a part of this panel. I'm looking forward to her comments as she brings all of this together and speaks really about the broader system as we talk about law enforcement and judges and state's attorneys and just the whole system and where we are now and how we're going to be able to put what Dean Lawson started us off with and what all the others in between have come to bring us so that CK can give us our closing. So CK, thank you very much. And we do have a number of questions in the chat and in the Q&A, and we are going to try to get to each of those, but we need CK to help us, and she'll probably answer several of them during her responses as well. Thank you, CK.
Well, thank you so much, Cynthia, first of all, for all that you do, for your tremendous advocacy and tremendous work at the NBA, at the ABA. There's a strong connection between our two organizations. Indeed, the current president of the ABA is a past president of the NBA. We also had the first woman president of both organizations. We also have here, Ben Crump, active in the ABA and the NBA, Dean Lawson, extraordinary opinion leader, academic leader on issues of criminal justice reform. We have past President Juan Thomas, who is the president-elect of this committee. We have such great synergy between the two organizations. Paulette Brown was probably, we still stand on the shoulders of the past president of the NBA and the ABA, Paulette Brown. So there's a lot of solidarity and work that we do together, and it's extraordinary. And I'm very, very happy to be here today. And Cynthia, thank you for including me. And to hear our past president, Ben Crump, and who is, I agree with you, he is one of the foremost civil rights lawyers of our time. And I say that not because we see him on television, because we do. Not because we see him fighting every single day for policing reform, for social justice, but because he has the heart. He has the heart of a leader, of a lawyer, who fights for the least of these. Now, many of us are in that space. We fight for the least of these, but Ben has a special blend of compassion, humility, and power. And with that combination, he's able to leverage to bring about change, not just in a locality. He's now in Memphis, but on a national scene, a global scene. And that's what we need. That's what social justice is about. So ladies and gentlemen, I just want to take a moment to thank all of the speakers today who have gone before me for giving such extraordinary information, statistical analyses on what our system entails today. And we cannot, there's no one who is listening to this panel today that can be satisfied with our criminal justice system, satisfied with where the policing efforts are in this country, satisfied with what we see on TV, satisfied that we saw for 8 minutes and 46 seconds, which actually was 9 minutes and 29 seconds, of George Floyd being brutally murdered before our very own eyes. And so when we talk about the status and the state of affairs when it comes to criminal justice reform, policing reform, not a single member of any bar in this country can afford to sit down and say, well, let's let someone else take care of that. Because ladies and gentlemen, I'm here to tell you, it hits home for each of us. This is not a social economic issue. This is not really a Black and brown poor community issue. It's an American issue. It's a humanity issue. It's a society issue. And let me give you a concrete example. If I can share something that happened to me in 2020, during the time when I was serving, yes, as president of the National Bar Association. I was in the middle of a meeting, a Zoom call, much like this. And I always keep my phone somewhere where I can see it because I have 2 sons, a 17-year-old and an 18-year-old. At the time, they were 16, they were 15 and 17. And I got a text from my 17-year-old saying, Mommy, we've been stopped by the police. I only have 2 children, ladies and gentlemen, 2 boys. African-American boys living in the Atlanta metropolitan area. They were headed to their little prep school, so they were in uniform. And this was the one day that they took my more flashy sports utility versus their age-appropriate little vehicle that they usually drive that's safe, but it's age-appropriate. And they were stopped by the police for no reason, other than they were driving in a flashy, some would say, sports utility vehicle that is at the top of the list of vehicles that are stolen, at least in the Atlanta metropolitan area. And ladies and gentlemen, when I tell you that I suffered through 3 hours, 3 minutes, it felt like 3 hours, of the most painful moments really of my life. Because you see, I can, as an individual, as a person, as a leader, as someone who cares about social justice, I can endure a lot personally. I really can. We all can as adults. But my children, who are innocents, who are young Black men being stopped for no reason, that hit a chord for me. And all I could do was get on my knees and pray. And pray that I not be that statistic, that this not be the narrative of my life, that my 2 boys would be taken from me at that moment, because in Atlanta, much like in other cities, there was less than a 50% chance that 2 Black men in a flashy vehicle like that would survive, not would be changed, but would survive being stopped by the police. And so thankfully, they did survive. Thankfully, they did survive, but that has forever marked me, because if ever there were anything to renew my commitment to social justice, it was living in that moment and thinking that my children could be George Floyd. Not my child, my children could be George Floyd. And that, ladies and gentlemen, is about as honest as I can be about why we have to fight. And why this fight is not just a fight about urban areas, low-income families, Black and brown communities, the least of these. It's about the least of these, of course, because there's disparity every single day that we see in criminal justice, in the implementation of policing reform, and where we are in this country. But it affects each and every one of us. And as officers of the court, we each took an oath to serve our communities. If you're a tax lawyer, you took the same oath as I did, doing catastrophic injury work, as Dean Lawson did, as the dean of a law school, as Cynthia Swan did, doing the extraordinary work that she does, April Love, as Ariana, as Brittany, we all took the same oath that Ben Crump did when we graduated from law school and became members of the bar, to serve and protect our community, even if we end up practicing tax law, catastrophic injury law, commercial litigation, opioid litigation, employment discrimination, civil rights work, human rights work. It's all the same oath, ladies and gentlemen. So as lawyers, we cannot divorce ourselves from the duty that we have to our community, because, ladies and gentlemen, it's going from the down up. Homelessness today, when we talk about the criminal justice system, our jails are filled with people who are homeless, and we know that this eviction moratorium is going to dissipate soon. One day, there will not be an eviction moratorium, and that's going to cause an impact on our criminal justice system if we don't get serious about policing reform today. Homelessness impacts not just low-income areas, but high-income areas, because it seeps into every single community. It's a societal issue. It's a societal problem. It's all of our problems. Civil rights issues, voting rights issues. Ladies and gentlemen, it's all intertwined into policing reform and criminal justice reform. So if you feel that you can put on blinders and say, well, you know, that's not really my area of focus, let me leave that to those who are out there in the forefront of the movement of fighting for social justice, you're not going to be able to do that, because the chickens are coming home to roost to all of us. That's why I started my comments by saying what happened to me. I felt like I was living an out of body experience, because I can tell you, I do speak multiple languages. I have traveled the world as a lawyer. I do have more awards, ladies and gentlemen, I'm so humbled by them, than could fill every wall in my office. But none of that meant a single thing to me if my children did not survive being stopped by the police. None of it. None of it. And so my message to you today is, what can we do? What must we do as officers of the court? Past President Juan Thomas in Chicago, what must we do? Reverend Jesse Jackson and his wife, Jacqueline Jackson, are in the hospital right now with COVID. We must pray for them and pray for all of those people in the hospital, because that COVID has taken its place even in the criminal justice system. How inmates are treated with COVID, the inhumanity of a disease that ravages our communities and is not concerned about color, ladies and gentlemen, not concerned about wealth, not concerned about creed, not concerned about cultural heritage. It is so contagious, this Delta variant, that within 10 seconds you can catch it. So when we talk about criminal justice reform and what we can do, what we must do as officers of the court, we have to do what we swore to do when we took that oath as lawyers in our jurisdiction. That we have to look out not just for ourselves, but for the least of these. That we have to be proponents of criminal justice and policing reform, that we must support the George Floyd Justice and Policing Act. What does that mean? That means something as simple as calling your senator, calling the Senate lines, and not stopping in your church, because we're in a virtual format now. In your church, speaking truth to power, having people in your church, in your organizations, speaking truth to power and telling them we need criminal justice reform. Make a call, a simple call, because one call to the Senate can make a difference. When they know eyes and ears are on them, it can make a difference, because they are what? Elected officials. On a statewide level, see, I live in Georgia, and I'm not going to be political because that's not what we're here to be. But I'm living here in the state of Georgia, where policing reform and the need for policing reform are at the forefront of everything that we do. Even when you deal with voter suppression, policing reform and our criminal justice system Those things are intertwined. You suppress people's right to vote. People are going to protest. They're going to take to the streets. They're going to get arrested for civil disobedience because that's what's happening. The prisons are going to be crowded. There's a trickle effect that's all connected. So as lawyers, we have to be advocates, those advocates of more than just what we do every day, but social justice for the least of these because it involves all of us. So in our communities, whether you want to be or not, people look up to people in the legal community. We are leaders. We are opinion leaders. We are people who, when they have questions about voting rights, civil rights, policing, what are my rights, they're going to call lawyers. And if you are in the African-American community, they're going to look to you 24/7 for answers. How do you explain my child being shot and killed by the police when all he was doing was talking on his phone? Attorney Hoffler. Those are the calls I get. How do you justify my child going to a hospital with COVID and being turned away twice? And the third time when he was taken to another facility, dying in my arms. How do you explain that, Attorney Hoffler? How do you explain that when I go to prisons, like Ariana was talking about, when I look at the statistics, when I look at recidivism, how do I stop my child who's been wrongfully arrested, who for 30 days was in a juvenile detention center and came back a different man or woman? How do I stop him or her from being that statistic? As lawyers, we've got to stand up and we've got to fight for criminal justice reform. We have to stop looking at everything through the parameters of black and brown. Oh yeah, the system does pigeonhole us. For sure, African Americans are treated differently. Black and brown people are treated differently. The Latinx community is treated differently. Native Americans in this country are treated differently. There's an uptick of violence against Asian Americans in this country, without a question. But when we talk about solutions, we have to talk about American solutions. We should not be talking about whether the right to vote or policing reform on political lines, but the only way to break through that is for us as lawyers to fight for justice, not Republican justice, not Democrat justice, but for justice, because we are the ones who are drafting the laws. We are the ones who are advocating for the laws. We are the ones in our communities, and we are the ones who people listen to. So we've got to be advocates. We have to be aggressive and assertive in our bar associations like the ABA. We have to fight for collaboration, for solidarity in our ABA, because the ABA is a powerful organization, just like the NBA is a powerful organization. We are the ones who are actually responsible for many members of the bench being on the bench. How do I know that? Because as a National Bar Association president, we had a very close working relationship, like other affinity groups, with the administration, with justice, and making sure that we diversified the bench. Because we know that diversity brings about not just the fact that there's someone who looks different, who's not a white male or just a white female on the bench. And there's nothing wrong with being who you are. But when there is a lack of diversity, sometimes there's a lack of diversity of opinion, lack of diversity of thought, lack of diversity of rulings that negatively and disproportionately impact a certain segment of the population. So we've got to push for that. And I'm proud to say that some of the nominees, and some have been confirmed, came from our NBA list, just as I'm sure the ABA can say that. So we've got to push for justice as lawyers, and remember the oath that we took, Cynthia, that oath that we took to protect our communities and not just sit back and make money. Don't get me wrong. There's nothing wrong with making money, but you can do good while making money. As I tell my longest standing client, Reverend Jesse Jackson, who's been my client for now 33 years, the more I work in the private sector, which is the only place I've ever worked, and try to bring about change in helping people so that I can get compensated, the more I can give and will continue to give on a pro bono basis to the civil rights movement, to Reverend Jesse Jackson, to Rainbow Push, to all the other organizations. So for those of you who are saying, well, what can I do? I mean, I'm in the private sector. I don't even know what social justice means. Oh, there's something you can do because you can make a phone call. I think Ben Crump said something that stuck with me and always sticks with me when I hear him say it. The reaction to George Floyd by people in different communities. One community, like me, that could be my son, that could be my child, and I felt that was almost my children. And in other communities, recognize the tragedy and the gravity of it, but never once feel that it could be them. Because our system of justice is not set up that way. So until we all feel that it can't be us, people who have a law degree and that homeless person on the street, we will never see justice, and our roles as lawyers will never stop. Justice for one is justice for all. Injustice for one is injustice for all. So ladies and gentlemen, in closing, I want to say this. It's never too late to get engaged in this fight. Pick a fight. Pick any fight. Social justice, this police brutality. Pick the George Floyd Justice and Policing Act. Pick voting rights, which should not be partisan. People should have the right to vote. You don't have the right to vote. You don't have the right to vote for senators who could help to pass the George Floyd Justice and Policing Act. It's all connected. Pick a fight. COVID. The disparate impact on our communities with COVID. Pick a fight, ladies and gentlemen, but don't sit down on your hands and collect the money and feel like you're giving if you give money to a church or an organization. No, that's not what's required of our profession. And if I've said nothing else to you that you will retain, just remember that there's a struggle out there. And when you look to the left of you and you look to the right of you, you need to decide what side of the struggle are you going to be on? Are you going to be someone who's struggling for justice? Or are you going to be someone who sits on your hands and rests on your laurels until the injustice reaches your front door and the roosters come home to roost? Thank you.
Okay, thank you so very much. I appreciate those comments. We do have questions that we're going to begin to respond to. And this first question, I am going to throw to Dean Lawson. And it is in reference to the difference in outcomes in Ferguson versus Louisville versus Minnesota. How much of that is attributable to the individual people who make up the grand jury or prosecutors/judges and their discretion, rather than differences in the individual cases or the legal strategies used?
Thank you so much, and thank you for that question. And it leads me into even reacting also to what C.K. Hoffler, our immediate past president of the NBA, brought up in her real life testimonial to us. And that is a real fear that she had because of the real consequences that so many in our community have experienced and have complained about for centuries, really. But in Ferguson, and the question references Ferguson, was the first time that we saw the Department of Justice, the government, documenting, acknowledging, and proving that what we have been complaining about is real, and that we are suffering at the hands of the government at times, police at times, and even excessive ticketing and abusive practices of fees and fines, as well as the use of dogs and etc. So I would just direct the audience to the Department of Justice's Ferguson report as just a point of real facts and data as it relates to why there is a fear, why there's a real concern. And that is where the Black Lives Matter movement started in Ferguson, even though we know it a lot from today with George Floyd. It started with Michael Brown. So as it relates to grand juries, that issue is a real issue as well. And we see documentation of videos, and we didn't see it in Ferguson, but we've seen it in other cases. And the issue becomes not what happened, right? Because we have videotapes, either body cam or bystander video that documents what happened. Do we believe what we see? Are we open enough to believe what we see? Can we overcome the presumption that police officers are not criminal? Like we're taught to respect and believe and think as friendly and protective police officers, but in these cases where we see actual videotape of something completely contrary to that training as children, can we overcome that perception? And I think that's what's at play in these cases, more than individual strategy and lawyering. But it is important for prosecutors, and we saw this in the George Floyd prosecution, to acknowledge implicit bias. And they acknowledged that in the closing argument, where they addressed the idea of the superhuman. If you recall the closing argument, the prosecutors addressed to the jury that there is no such thing as a superhuman. And this is an important component of advocacy. We saw in the Trayvon Martin case, the prosecutors say, this case is not about race. It's about the difference between right and wrong. And that was an unsuccessful argument because race was at the heart of what the jury was actually thinking about. And so it's important for us as advocates, as successful advocates, to address what the jury is actually thinking about, perceiving, even if it's a misperception or an implicit bias perception. So they went to the heart of the matter, that there is no such thing as a superhuman, which was part of the American culture from the 80s, where we had the super predator legislation and other things that jurors or individuals, just people believe that Black people are more dangerous or that there is a reason to use more force. And it's documented with the psychology, the empathy gap, which has created the excessive force gap. So as Ben Crump talks about transparency, it is real. So whether the transparency is the actual bystander video or the suppressed cam video in the Ronald Green case, it's important for us to continue to push, because when you look at the initial police reports in George Floyd's case and in Ronald Green's case, neither of those reports reflect the actual video. And that's a real problem, and that's a real problem of reform that still needs to be addressed. And just the last point I'll say as it relates to this, the standards for the prosecutorial function address this explicitly, and they prohibit implicit bias. And they say that a prosecutor's office should be proactive in its efforts to detect, investigate, and eliminate improper bias, with particular attention to historically persistent biases like race in all of its work. I think our discussion today is clear that race is a historic and persistent bias as it relates to our protection and excessive force in these cases. So I'm so grateful for this discussion. Reform is needed, and I agree with C.K. Hoffler. We are on a push for justice, and justice for all, as Ben Crump said, according to our Declaration of Independence.
Thank you, Dean Lawson. Thank you so very much. And we are coming up on time, but there is a quick question that I'm going to throw to you, President Hoffler, and that is, what political pressure do lawyers need to make to get Congress to pass the George Floyd Justice and Policing Act? And also, how do we get the state legislatures to pass similar legislation? And so we need a quick answer to that, and then we will close it down. And I want everyone to know that we will attempt to answer your questions offline, but this is a question that we're going to answer up front. And then there's some questions related to mental health issues and others and recidivism that we will be throwing to Ariana and to Brittany afterwards.
Well, certainly, and I'll be quick with this. Cynthia, first, we have to call the Senate. We have to call the US Senate, have coordinated efforts calling them and insisting on the passage of George Floyd Justice and Policing Act. Believe it or not, That's very impactful. Sending letters to the US senators who sit and those who in particular who are resistant, that has an impact. Also coordinating with those leaders like Ben Crump, Lonita Baker, Lee Mayer, Chris Stewart, all of those people who are in the forefront, who are fighting these cases, a coordinated effort, which is what we have now, and making sure that those efforts are coordinated so that we know when it comes to any of the issues in the George Floyd Justice and Policing Act as it is now, that we are taking into account the realities of practitioners. Also, interfacing with the Justice Department. Kristen Clarke is a gold mine for civil rights, human rights, voting rights, and all of the issues in the policing reform. So supporting the efforts of Kristen Clarke and the Justice Department when they go into communities such as in Kentucky or in Minnesota and throughout the country, and they have these committees or commissions or teams that are looking at pattern and practice, supporting that, looking at the reports, spreading the information to the groups that you are a member of, whether it's bar organizations, whether it's social groups such as the Links, such as different organizations that you might be a part of. And then finally, making sure that you as an individual, as a lawyer, are on point and understand the issues. And if you don't understand the issues, reach out to, for instance, the ABA Civil Rights and Social Justice section, because they do understand the issues. They're a reservoir of information. You can be plugged in and get involved. And we're preaching to the choir because many people are members, but reaching out and bringing in other members so that we're on point with the issues and you're not out of line with what practitioners, Justice Department, and those on the front lines are sensing and seeing.
President Hoffler, thank you so much. Thank you to the entire panel. You have been incredible. The ABA Civil Rights and Social Justice section, and especially the Criminal Justice Committee, are pleased and just thrilled with the presentations and with all that has occurred. We had a nice participation in this particular webinar. It is important to remember that this webinar is the first in a series of webinars that we are going to have on criminal justice reform and the moral responsibility that I think we did prove today. We do have a moral responsibility to view criminal justice reform and to be actively engaged in actually implementing it. I want to thank my co-chair, Ashley Baker, who is on this call, as well as our Vice Chair, April Love, who is also here. These young ladies are incredible, and they really introduced us to other incredible young ladies, as in Brittany and Ariana, and brought them into the fold as well. And so we really appreciate that as we have our younger lawyers coming through in a very powerful way that is extremely important. And they're talking about an area that we know is extremely important as well, and that is the juvenile justice work that needs to be done in order to help with mass incarceration. I think that it's important to know going forward that we do expect to begin to have a series that will have prosecutors, law enforcement, judges, state's attorneys, and more. And we intend to continue to delve into this work and into this process. Thank you all for joining us for this free webinar. We'd like to express our gratitude again to this esteemed group of panelists. You are all doing such critical work, and we want to thank you for taking the time out of your schedule to share your experiences with us. Attorney Ben Crump had to leave. He is continuing to do that in very important on-the-ground work, defending and protecting and advocating for our members in our society who are really coming up against tremendous pressure and pushback and need his assistance and the assistance of all of us in the criminal justice realm in an effort to determine how we can best support the system and those of us who are in it. So thank you again. The best of luck in your work, and everyone stay safe as we move forward. And please look forward to us beginning to give you more and more opportunities to join and to have the discussions around criminal justice reform. Thank you.